Hello and welcome to the highlights for Chapter 1, Constitutional Democracy. This is Mr. Rodman. Please keep in mind that this is just going over the highlights, what I call the top 12 highlights from this chapter. It is not meant to replace your reading or your reading guide or your concept cards, but it is just to help you reiterate and reinforce and emphasize the highlights from this chapter in terms of the concepts. So if you need to pause this, if you need to go back and listen to a slide that I'm covering again, please feel free to do so. That's the purpose of why we're carrying this out, and hopefully it will help you in terms of putting the concepts together. The first highlight we're going to cover is having to do with constitutional democracy. Obviously, we could not have a direct democracy, which we'll talk about in a second, but the idea here was we had a constitutional democracy that was founded on principles that then the people would elect the government, and as a result of that, the founding documents or the guidelines for the government would be enshrined in those in a constitution, and as a result, people would be elected to office as a result of that constitution and the will of the people, the popular sovereignty of free and fair elections. But the power would be limited because of the pluralistic tendency, and by pluralism I mean multiple levels and multiple branches of government, each competing for power within the government. The power would be fragmented, and as a result, elected officials would then have to work together with others in order to accomplish what the majority ultimately would want to accomplish, hopefully in that respect, and we'll look at more in terms of how the minority is protected as a result of that. But the idea is that the majority rules while the minority is protected, and the Constitution is basically where they get their power and authority, but it is limited in that nature by the will of the people through voting. Direct democracy is when people all get together in a town and they basically vote on everything. A representative democracy is more of what we have in the United States and in most countries, in which they elect leaders who represent them, and the will of the people is being spoken in representing those leaders. But the idea is that those leaders are only given power by the people, and that power can be taken away by the next election, in which the voters decide they don't want them anymore. So a direct democracy is one in which everyone is voting on everything, and they're the ones that are making the laws. We don't have that. We have a representative democracy in which we elect our leaders through the republic, and the republic form of government, and as a result, those leaders then take the charge as to what we want them to do, and they carry it out through whatever level of government that they're a part of. We talked about direct primary, in which people are voting for candidates for office for their party, and then those primary candidates will go on in the general election, in the November election, to represent their party against other parties and try and win the actual election, the general election for that particular seat. An initiative is a petition you might see outside of a supermarket or outside of a hardware store, in which someone's trying to get an issue to be made of significance and put on the ballot. That's what we call an initiative or a petition. Referendum is when that issue gets placed on the ballot because so many voters signed the petition saying that it was important to them. A great example of this in Maryland was the casinos and the slot machines bill. That was a referendum petition that started that way. The legislature actually also picked it up and decided to place it on the ballot in order to serve the will of the people. And then a recall is when you're removing an elected official, the most famous being in California, where the governor was recalled after the power crisis, in which Governor Gray Davis was recalled and Arnold Schwarzenegger was elected after that. So that's a recall in which the voters decide to remove that person that they've elected because of something that they've done, some type of political malfeasance. In this case, they were concerned about the power the power companies charging too much and rolling brownouts and that sort of thing. So that's where the will of the people speaks yet again to say, hey, we changed our mind. We really don't want this person in office. In terms of the different forms of government, let's talk about number 4 for a second. An autocracy is when basically one person rules. We think of that as totalitarian government. An oligarchy is when we have a small group of people. Think of that like in China, where there is a unitary, a central form of government, but it's a small group of people that are basically ruling. And what we have is democracy, in which all of the people are voting. The popular sovereignty or the will of the people is emerging, and as a result, the people's choice is basically who goes to Washington, who goes to the governor's office, who goes to the state house, and those are the elected officials that represent the majority of the public, or at least the majority of the public who votes. And that's the type of government that we have. Now you think about a monarchy in which you have a king or queen. An absolute monarchy would be they would rule and there is no other type of parliament or elected government. A constitutional monarchy, similar to what Great Britain has, is they have documents that basically have had power of the monarchy, but really it's more of a ceremonial position today. And as a result, the parliament really handles all of the governing documents. So the will of the people in a constitutional democracy or a constitutional monarchy is where the people are electing officials to parliament. But they still have a monarchy, a king or a queen that as part of their government, but it's more ceremonial in nature. And then we talked about totalitarian dictatorship in terms of that autocracy, in which someone is basically in charge and they say what they say goes, and the people really don't have a choice or a say in the matter. So what values in our democracy? We talked about this in the opening of this unit when Dr. Magleby in the text talks about personal liberty and the idea of having certain personal freedoms. We think of them today in terms of the Bill of Rights, but also the individualism to be able to speak out, to be able to make your voice heard in terms of voting, in terms of things that are important to you, and that sort of thing. Equality of opportunity in terms of everybody having an equal shot. We know that's not always true in terms of the opportunity that's out there. It isn't a perfect system, but it is a system that is continually changing. And even with the Constitution, we've been successfully amending it for 200 years. We've done it 27 times in trying to make that equality of opportunity more beneficial for everyone involved. So it's not perfect, but it is a work in progress. And then popular sovereignty, the idea of the will of the people, and trying to express that through election after election every 2 years or every 4 years for president, for instance, in which the will of the people speak and elect their leaders that then pass laws to govern over us that then we must follow. In terms of the processes that relate to this democracy, we're talking about elections that are free and fair, that people are able to go in, they're able to vote, they don't have to wait for days on end in order to cast their ballot. The majority or the plurality rules. Remember, majority is when you have more than 50% of the vote. Plurality is when you have the most votes, but not necessarily a majority. So there may be more than 2 candidates that are running in a plurality. The person with the most votes wins, though they do not have a majority. A majority of the votes is when someone gets 50% or more than 50% of the vote, and that would be majority rule. Free expression, again, we go back to the Bill of Rights and we'll take a closer look at those, but the idea here is that people have the freedom to speak. People have the freedom to express the religion that they believe in. They have the right to speak in the press and make their voices heard, to petition their government for a redress of grievances, and really to express themselves in those open ways and not be punished by the government for doing so if it is in a civil and orderly manner. We also have the right to assemble. We have the right to protest, and all of those outlined in the Bill of Rights, and we'll talk more about that when we get to the Constitution in Chapter 2. But the idea here is these are important to democracy because without them, we can't express the views and the concerns of the will of the people that they need in order to make informed decisions to be a part of that democracy. In terms of the political structures, and we'll go into a lot more detail on these in future chapters, but federalism, the idea that it is national and state government working together, is an important part of our democracy because it separates those powers. It checks those powers. No one can have all power as a result of this. It is really limited in that scope because of federalism, because of what we'll talk about in Chapter 3, the idea of national, state, and local government working together. It's also national, state, and local government splitting the power. And that separation of powers that we look at here is also not a national branch having all of the power, even at the national level, but breaking that up into different branches that share the powers. And we'll take a closer look at that as well in terms of the executive branch having the power to enforce the laws, the legislative branch to make the laws, and the judicial branch to interpret those laws. So that's really important too. Bicameralism, it's not just one chamber within the legislative branch, but bicameral, like bicycle, cameral, Latin for chamber, bicameralism meaning two chambers in which they have to come to consensus, they have to come to agreement in terms of moving a law or an initiative forward in terms of a legislative policy. Part of that is checks and balances then on those different branches of government, checking and balancing each other to make sure that no branch of government or no level of government has too much power. And then enshrining all of the rights and the personal freedoms we talked about, those individualism and free expression and equality of opportunity in the Bill of Rights, those first 10 amendments to the Constitution. And we'll look at those in more detail in the next chapter. But the idea here is that those rights are a part of what makes our democracy so great, is the political structures that are in place to limit government, to limit the power of government in terms of what really is the will of the people. Now, we talked in class about the natural rights and the philosophers that incorporated these rights. I'm going to go through this fairly quickly, but please pause or go back and look at what we did in class, what's in your notebook related to these. But the idea here is that natural rights aren't given to you by the government. They're a higher power that is basically giving you those rights. You're born with them. They're inalienable. They can't be taken away by any government. And any government that lasts isn't going to be able to maintain the will of the people because of the natural rights that they may be infringing upon. So this is really important. And we talk about this in terms of life, liberty, and property. Jefferson would talk about it in terms of the pursuit of happiness. But again, these are inalienable rights. They're protecting man's natural rights. And Hobbes talked about this in terms of the state of nature in which man was bad and would err on the side of greed and doing what was important for them. And those natural conditions exist. But the idea of a social contract was that we would limit the power that man had to basically rein himself in through government, and that social contract would help in doing so. John Locke talking about the social contract in terms of life, liberty, and property, the rights that are inalienable, that can't be violated by a government who steps in and says, I want to take these from you. If anything, they should be protected by government, and that's the importance he was stressing on that in terms of that state of nature. Montesquieu looking about in terms of government having a check on power, making sure that any part of government is not becoming too powerful and going beyond the will of the people. And that separation of powers that we'll talk about in the next chapter, you see here outlined in the legislative branch, the executive branch, and the judicial branch, all of that limiting the power of any part of government from becoming too powerful and usurping the will of the people. And then Rousseau looking at this from the perspective of protecting those natural rights, of what we lose through a social contract, we're gaining in keeping and enshrining those natural rights of life, liberty, and property that the government can't take away, but the government has to do what it can to maintain those rights and to ensure that those rights are protected. All of those are important in terms of what we're talking about here in terms of the will of the people, of enshrining democracy and protecting democracy to support the will of the people. this becomes most evident in Shays' rebellion because we have Daniel Shays and other farmers that are being foreclosed upon. Their mortgages are being foreclosed upon because they can't pay their bills. And as a result, the central government has no power to put down this rebellion. They can't tax, they can't pay an army, even though they can pull one together, if they can pull one together. And these are big issues because of that. So Shays has an easy time because there's no central government to basically put down the rebellion. And this was really a warning call for many of the founders to say, hey, we need to do something else in terms of creating a central government that at least has more power, even if it's limited in terms of its government. And we need to craft this carefully, but we need to do it in a way that allows us to put down a rebellion like this without shaking the institutions of our government. So this is really where the Constitutional Convention is called to fix the articles, to really amend the articles. What would happen is not to amend the articles, but to throw out the articles out altogether and create a new constitution. But that wasn't the intent when they started. The idea was they were going in to amend the Articles of Confederation to solve the problems of a weak central government and to really try and find ways to make it more powerful to put down a rebellion like this. Like I said, what would come out of it is something very different than amending the articles, but throwing it out altogether. It's important to note compromise here in terms of the Constitution. There were a lot of compromises made. James Madison, who we call the father of the Constitution, who also wrote many of the Federalist Papers with Alexander Hamilton, one of the things to think about here is he sat very close to what was going on in the action every day in the Constitutional Convention in Philadelphia. The whole idea here was because he wanted to make sure this was successful. He wanted to make sure we could carry this out. And part of that was indicative of compromise in making sure that the big states were still in it, but the small states were happy because he knew we were going to need 9 of 13 states to approve this thing in order to make this happen. And so you see a lot of compromises in here, as we talked about in class with the Virginia plan, the New Jersey plan, looking at slave states and non-slave states, really tabling that issue in order to ratify the Constitution, and other compromises that we see here. So the New Jersey plan, the idea of one state getting 2 equal pieces of representation, ultimately would be senators. New Jersey gets that plan. Virginia having a much larger population, they want the legislature to be based on population, and so we would look at the Virginia plan and the New Jersey plan in the Connecticut Compromise, or the Great Compromise. The idea there of kind of taking the best of both worlds. So we have one legislature in the bicameral or 2-chamber legislature, one that is the Senate based on 2 senators for every state, and the Virginia plan then that is based on a House that is based on population. So compromise is very key to ratifying this new Constitution. So here's an example. We have equal representation of the states in the legislature on one side. We have state represented by population in another, and this is where we get the Connecticut Compromise. The House is based on population, the Senate equal representation. We have another here where one camp is looking at the direct election of the president by the people, another by electing this president by Congress. Ultimately, the compromise is the Electoral College, which we'll talk about later, which basically elects the president, allowing the will of the people to still be a part of the process, but Congress isn't doing it either. It's electors that are basically voted on by the people to make that determination as to who the next president would be. Another compromise, we have the single term 7-year for president versus the life term. The idea of and concern of a life term was we're going back to King George. So now we have a 4-year term with unlimited re-election. Ultimately, we would have the 22nd Amendment, which would limit that to 2 terms in office, or 10 years total. We have Supreme Court justices chosen by the Senate as an idea, or chosen by the president. The compromise that ultimately comes out of this is Supreme Court justices that are chosen by the president, confirmed by the Senate. So you can see a lot of the compromises that are at work here in terms of trying to make the states happy in order to get to that magic number of 9 out of 13 to compromise. And that's really important because the whole idea of representative democracy and the will of the people is also about limiting government to make sure that the will of the people is supported. So we do see some limitations on that popular sovereignty, that will of the people, in that the Senate isn't originally elected by the people, neither is the president. Judicial review isn't is going to take its form as we go forward, but there's other checks and balances that are going to limit the will of popular majorities. It's going to be difficult to pass legislation in both chambers and then get the president to sign it. That's not going to be an easy feat, but it is something that is going to limit the power of government and support the idea of limited government and the will of the people in that process. It's important to note here that Madison is known as the father of the Constitution, and there were many people as part of that 55 that were in the room creating that document. But the idea here was he was really trying to maintain order but limit government. He was really trying to create a government that would work and that would put down a Shays rebellion, but would also be limited in nature to not overrule the will of the people. And that's where he would join Hamilton in outlining those in the Federalist Papers. He talks about this in Federalist 10, which we'll go into greater detail in looking at the idea of factions. How do we limit interest groups? How do we limit those groups that are going to try and basically convince the government that their issues are important? How do we make sure that the majority is supported while the minority is protected? He outlines this in 39 with the compromise, the great compromise, and looking at the Virginia plan and the New Jersey plan. He looks at this in Federalist 51 with a separation of powers, and you see this again and again in the Federalist Papers. He's really trying to win over the American people to this new Constitution in that it's maintaining and supporting the people's rights without giving government too much power. And that's a really important point to make here. The last things I want to cover just have to do with the Anti-Federalists, because that was a very strong movement led by people like George Mason and Patrick Henry in Virginia. They were really concerned about not having a Bill of Rights enshrined in the Constitution. Now, Federalists looked at that and said, hey, we've limited the national government. The states are really the ones that have the rights here. They're the reserve powers. Anything that's not specifically enumerated that the national government has is really the power of the states. But the Anti-Federalists had concerns government was going to be too strong. They had concerns that Congress was going to restrict commerce through the Commerce Clause, was going to weigh in too much on that, and it would restrict the state's ability to be able to regulate commerce. They also thought that they were going to be so far removed from the people that they wouldn't care about what the people were saying, and that it would take power from states and as a result, because they're distant from the people, they wouldn't care how much they were taxing them. And all of that is obviously a bad idea. Because you're limiting the will of the people at that point. And then the other concern was that the president was going to be this king all over again, and the concerns of King George would then be problematic for trying to get the will of the people accomplished in what would be Washington in the national government. So those were all concerns of the Anti-Federalists, and really James Madison eventually would come around because the concern was that the concern that was being touted at the time was, hey, the Anti-Federalists said, hey, if you're not going to add a Bill of Rights, then let's open up and hold another constitutional convention and call this and open this up to amending the Constitution. And we know what happened the last time they did that. They threw out the Articles of Confederation and they launched into the creating a new constitution. The last thing James Madison wanted to do was open up another constitutional convention and risk everything that they had worked for. So at that point, he did work with people like Patrick Henry and George Mason to establish a Bill of Rights, 12 amendments, which would ultimately become 10 amendments to the Constitution that were ratified. He got people like them on board, the Anti-Federalists like Henry and Mason on board in order to ratify the Constitution and ultimately enshrine the first 10 amendments, the Bill of Rights, to the Constitution. But those were the concerns that they had. The concern was really that the states' rights would be usurped by a national government. The Federalists were arguing back that wouldn't be the case, that these delegated or enumerated powers were really specific, and the states were really the ones that had the reserved powers or the rights. But ultimately, the Bill of Rights, the first 10 amendments, would be added in order to make sure that the national government wouldn't have too much power in limiting the power of the state governments or the power of the people in maintaining those rights. Some important ones to know: writ of habeas corpus, obviously the knowing what you're being accused of and what you're being charged with would be suspended during the Civil War under Lincoln, but this would not be allowed to be suspended. And the idea here was in order to make sure that the people wouldn't just be thrown in prison like many people were during the reign of King George. Bill of Attainder, certain groups of people wouldn't be charged with or tasked with having to follow specific rules, but it was the will of the people, it was the law of the people. It wouldn't be a Bill of Attainder that was specifically discriminating against particular groups of people or particular individuals. Ex post facto laws would not be allowed. You couldn't pass a law about something that people had already done or had already happened. You would have to grandfather them in. And then you would have to have a trial by a jury in criminal cases. Are really the important pieces of the Bill of Rights that were added there. The privileges and immunities, ultimately, that what you have under one state, such as a driver's license, would be privileges and immunities that would be honored and granted, such as a marriage license by other states, and we'll get into more of that. Immunities in terms of what people may be immune from or protected from under the Bill of Rights would be protected there under those first 10 amendments. The freedom of religion would enshrine that there is no religious test, and that contracts were protected, that Congress couldn't just step in and start creating laws that would limit commerce in that respect and specific contracts along the way. We'll see the courts step in and kind of draw some lines there in cases like Gibbons v. Ogden in the Commerce Clause, but for now, the idea of the Bill of Rights is that these are things that are most important in terms of protecting the will of the people and enshrining those personal rights and liberties that people like George Mason and Patrick Henry were most concerned about. So that really wraps up the highlights for this chapter. I hope you found this helpful. Again, go back and look at specific slides or go back and look at your reading guide. Definitely go over those concept cards and make sure that you know those terms and concepts for the quiz on coming up. And we hope you found this helpful. Definitely give me feedback at parts that you found helpful. And good luck. And I know you will demonstrate your awesomeness on the quiz, and I wish you well.